Okay, class, welcome to week 4. This week we'll be addressing chronic conditions and mitigating the frequency and severity of injuries and harms, as both of these categories are considered as public health conditions. Uh, let's start with a quick introduction on chronic conditions. Chronic conditions are really the real killers in our society. Most of the loss of life in this country is the direct or indirect result of chronic conditions. They are the root cause of millions of deaths every year, and there are many millions more who are disabled by chronic disease. There is also a relationship between chronic conditions and communicable disease. And as we know, our resources for addressing public health concerns and general medical concerns and chronic conditions are finite, meaning that as our funding goes toward the control of communicable diseases, as it is doing now in the teeth of the COVID-19 pandemic, we're really taxing our ability to address chronic conditions. So there is some relationship between the two as they compete for dollars. Chronic conditions are defined, and as you know, I like to start with definitions because that unifies us as a class in terms of the meaning of the concepts that we are discussing and studying. And we say here in the lecture that your definition is as good as mine, and that's because many people have many different definitions of chronic conditions. But generally speaking, the one thing that they all have in common is that a chronic condition is one which lasts more than a year, which requires ongoing medical attention, and which has the effect of limiting our daily activities. The most common examples of chronic conditions, of course, are heart disease and cancers. Not all cancers, by the way, because some cancers are caused by um, environmental causes, and we may discuss that later. But clinical depression is another example. Diabetes is another example. Hypertension, I suppose, would be another one, although that would be perhaps related to heart disease, respiratory issues. Um, it's always useful to look at statistics. I love the statistics because they give us a sense of the scope of a problem. But according to CDC, 50% of all adults have one or more chronic condition, and of them, 50% have more than one chronic condition. 26% of all Americans are limited in some way by a chronic condition. 70% of all deaths are attributable to chronic conditions, and 75% of the healthcare costs spent in this country are spent on the treatment of chronic conditions. There are many causes of chronic conditions: genetic stress, occupation. Think about some of the jobs that people do around the country, maybe not us so much, but in coal mining country, the incidence of black lung and other lung diseases resulting from just the essential nature of that job. Environmental exposures, people working in chemical plants are exposed to toxins every day. Medical error is a cause, lack of access to healthcare services, which is a concern that many of you have expressed in some of our earlier forums. Access to healthcare can lead to the development of chronic conditions and also the exacerbation of ones which we already have. And of course, diet, another concern which you guys have identified in your forums. Chronic conditions basically can be traced back to four factors. One is poor nutrition. The second is the use of tobacco and nicotine. I'm going to add to that. It's still nicotine, but not traditional smoking, but vaping or e-cigs as we know them today, and as we know that use of these products among our teenagers is epidemic. The excessive use of alcohol, and of course, physical inactivity. These are the four main factors leading to the onset of chronic disease. Dietary factors, of course, lead obviously to obesity. And here are some numbers again. I found these startling. In 1966, I guess about 50 years ago, a little more than 50 years ago, only 13% of adults were obese and 4% of the children. These are American numbers, by the way. In 2013 and 14, 35% of all men and 40% of all women were considered obese, and 17% of our children were considered obese. These numbers are projected to continue to increase and may go as high as 44% for men and women by the time we hit 2030. Obesity stemming from dietary ignorance or bad direction or education on dietary concerns imposes an enormous burden on the healthcare system because obesity then leads to other chronic conditions. Tobacco and nicotine used to be a much larger problem, but smoking has tailed off to some degree, replaced in large part by vaping or e-cigarettes. But 20% of Americans, according to a recent study, still use tobacco and nicotine products. I believe that if you added in the teen use of e-cigs, that number would be up slightly and would probably be continuing to increase unless, as a public health measure, government gets involved in regulating vaping and e-cigarettes as they did regular tobacco products some time ago. 13% of all teenagers have tried it. It's an open question as to whether or not it leads to tobacco use, but it doesn't really matter much because some of the experts say that it is even perhaps more addicting than actually smoking. And the exposure to the toxins in the products found in e-cigs are in common with the use of tobacco. They have not been in use long enough for us to really judge whether or not the lung damage or the rate of damage is the same, or whether or not they result in lung cancers. But time will tell, and I suspect that the news will not be good on this. So the governments of the various states are already moving to regulate this in a very, gingerly and gradual way by regulating flavored e-cigarettes, whereas perhaps the bigger problem is still ahead of them. The FDA has proposed some regulations on this, and I will investigate the current status of those regulations and make them known to you. The regulation of tobacco and e-cigarettes is mainly done also on the local level, even on the municipal level. When you talk about how certain municipalities will prohibit the use of these products in public, this is a good example of that. Alcohol is, of course, quite prevalent. Alcohol use is an endemic part of our culture, has been for thousands of years, and it can be used responsibly, but it also contributes to many diseases and injuries. including some of the preventable injuries we'll talk about in the second half of this lecture. Salt is always a fascinating one because, as we know, sodium is essential to the maintenance of human life, and yet the overconsumption of sodium leads to hypertension, heart disease, and possibly stroke. Sugar, it's a product used in flavorings and sweeteners and desserts and soft drinks, and it's I find it to be quite appealing. I like all of those things, and most people do. However, they contribute to diabetes, obesity, cardiovascular disease, and there's a possible link to Alzheimer's. So, how do we fight chronic conditions using the legal authority of the states or the federal government? Well, the legal authority to fight chronic disease uh, facilitates the use of testing and screening and treatment, vaccination. If you want to use the example of the HPV vaccination, that's an example. And in labeling, actually, government getting involved in the regulation of commerce or in commercial speech, regulating how products are labeled, how menus are written, how advertisements are written, and where they may be placed. These are all examples of public health authorities using legal tools to help fight chronic disease. Where does the legal authority come from? Well, as we learned before when we were talking about communicable diseases and when we were talking about the Constitution, we have in our federal system a parallel authorities. We have federal authority and we have state authority, and they're different to one degree or another. The power to tax is a federal power. The power to spend and appropriate the monies generated through taxation are also a federal power. The federal government has the power to do some regulation and has the ability to enact legislation which prohibits bias or discrimination on the basis of disability. Chronic conditions can lead to disabilities, so we have laws like the Americans with Disabilities Act, which mean that people who suffer from these disabilities cannot be discriminated against in the workplace. On a parallel track, the states, using their police powers, have similar authorities. They also tax, they also spend, they regulate, and they also have laws which protect the disabled. As long as the federal and state laws don't conflict with one another, they can coexist peacefully. When there is a conflict, then generally speaking, one or the other, usually the federal law, will contain preemption language. Remember, we talked about preemption early. In preemption, the federal law will say it is our intention to preempt this field. In other words, our law, to the extent it comes into conflict with other laws, will be the one which should be honored, which has takes precedence over the state or local law. So let's talk about the taxing power a little bit. The taxing power, look at your constitutions again. I hope you look at them frequently and keep them at your bedsides. But the taxing power of the federal government is found in Article 1, Section 8. The taxing power has been used as a hook or a justification for allowing the federal government to exert its power in the public health field. In the case of NFIB versus Sebelius from 2012, the U.S. Supreme Court considered whether or not the Affordable Care Act, otherwise known as Obamacare, was a valid exercise of federal power, or, on the contrary, whether it was unconstitutional. There, the Supreme Court held that the Affordable Care Act um, included a tax. That tax was what we call the individual mandate. Because that was deemed to be a tax, the law was upheld as constitutional, and the court recognized that the power to tax includes the power to change individual behavior. What we mean by that is that the federal government, by taxing a particular product, can exercise its power to discourage the use of that product by hitting you in the pocketbook. Therefore, federal and state taxes on tobacco products would be a good example. In New York City, well, it's probably even more expensive now. But at the time I wrote this lecture, in New York City, it cost $13 to buy a pack of cigarettes. So this is an example of imposing a tax on the purchase of tobacco products for the purpose of discouraging its use. The taxation of sugary drinks, soft drinks, SSBs as we call them, and high-fat, high-sodium food products is another example of that, using the power to tax, this time at the state and local level, to discourage the use of those products and to encourage instead people to opt for more healthy food choices. Instead of taxing a food they don't want you to eat, they can sometimes give a tax exemption or a tax break of some kind on the purchase of healthy foods. Now, the taxes which are raised, so-called vice taxes, because tobacco, eating high-fat, high-sodium foods, maybe the big jumbo soft drinks, these can be considered vices, I suppose. But the taxes raised from these vice taxes can then be plowed right back into the public health effort to help fund programs. So it has a salutary effect. Legal challenges are generally unsuccessful when we have people or entities which challenge these efforts to combat chronic conditions, but they are often quite contentious and get a lot of publicity. The power to spend is the flip side of the power to tax. The lawful power to spend is really the power to promote the general welfare, because these monies are supposed to be expended in such a way as to promote the health, safety, and welfare of the people. This is true at the federal level. It's also true at the state level. The power to impose conditions on the receipt of funds is another interesting example of this. The best example out of your text is where the federal government, Department of Transportation, decided that they would condition for the states the receipt of highway funds on those states enacting laws raising their drinking ages to 21. So if a state decided to leave their drinking age as 17, 18, or 19, they would not be eligible for these funds. This kind of a law was challenged, and the Supreme Court held that it was okay, provided the law served a legitimate purpose. Clearly, this one did, which was to, discourage youthful drinking. Choices and conditions are clear. The law was clear enough. If you wanted these extra highway funds, you had to hike up your drinking age. And the conditions related to a national program, not targeted specifically to a particular state. And these were national programs. And there's no real compulsion to accept the funds. In other words, if you wanted the extra funds, you had to raise the law. But it wasn't as if the government were going to take away all highway support if you didn't raise your drinking age to 21. That would have been too onerous. Under the Affordable Care Act, again, I'll say Obamacare. Most people know it that way. Again, the big case was the Sebelius case. And I'll get you some more material on this because it's pretty interesting. It also gives you I'm going to give you some snippets into the actual audio recording of the oral argument of the great lawyers who argued this before the U.S. Supreme Court, and just to give you a sense of what goes on up there. But in the Sebelius case, the Obamacare law initially not only did it provide insurance opportunities for many millions of Americans, but it also sought to expand Medicaid eligibility, and it conditioned the Medicaid funding in its initial form. This law said that unless a state agreed to expand Medicaid eligibility, it would lose all Medicaid funding. The Supreme Court, in its decision, said, that's too far, that's too onerous, and you have not given the state a fair choice. Therefore, they modified the law by saying that a state which did not expand Medicaid eligibility would lose the extra Medicaid funding, but would not lose all of the federal funding that it previously had. As a result of the Supreme Court decision, 19 states opted out of Obamacare, and as a result, millions of Americans were denied publicly funded health care. So that's an unfortunate consequence. The power to regulate is really the power to ban or limit the sale of harmful products like leaded gas, lead paint, powdered alcohol. I've never heard of powdered alcohol. Trans fats, things like that. Vaping, hopefully soon. Tobacco, of course. Age limits on the sale of tobacco and alcohol are examples of this. And also, as you know, now there's a burgeoning cannabis industry as it becomes in various states either decriminalized or legalized for medicinal use or legalized even for recreational use in different states now. Marijuana is on the menu, so to speak. But in legalizing them or decriminalizing them, the states are also imposing some limitations on the manufacture and sale. Caloric disclosure on menus and on food product packaging is imposed by FDA regulations, and restrictions on the uses of products in public, like the smoking ban in public, is another good example of that. Another big category is workplace safety. No matter where you work, there are some OSHA regulations which apply, and they're designed to make sure that there is some uniformity and a basic standard of safety which is imposed on all working places depending on the particular dangers that are intrinsic to that occupation. And OSHA representatives, those are federal. That's OSHA is a federal thing. The OSHA representatives will visit workplaces from time to time to make sure that a workplace is in compliance, and the penalties for noncompliance can be pretty severe. OSHA has imposed black lung regulations and regulations on silica and have tried to cut off or eliminate the shortcuts that industries were taking. Remember that the businesses, I don't mean to paint them as evil, but they do have a profit motive. And their bottom line is, for the most part, to make a product which is appealing to a public or to a customer down the line, and to sell it at the best possible price, and to garner a good section of the marketplace. And OSHA comes along and imposes some burdens on them about safeguarding their workers. And those safeguards cost them money and go to the bottom line. So there's a tug of war going on here between the profit motive at the corporate level and the public health responsibility of the state and federal governments. Finally, disability bias. As you know, and as you probably experienced in the places where you've worked, it's hard for disabled people, A, to gain the employment that they seek and to maintain those jobs once they have them and to advance in those jobs once they have them. And it's less difficult now than it was before, but that's primarily because the federal and state governments have enacted laws which protect them. So, on the federal level, we have the Federal Americans with Disabilities Act, ADA, and New Jersey has something called the Law Against Discrimination, which covers people with disabilities. It's laws like these which ensure that large workplaces, at least, are required to install wheelchair ramps to make the buildings accessible to their employees, also to their customers. But the focus of ADA, of course, is the um, uh, the employees and accommodations for hearing impaired patients and use of braille signage on elevators. You've seen this yourselves. Um, Remember that obesity itself can be categorized as a handicap or a disability in someone who suffers from morbid obesity, not just someone who has put on a couple extra pounds, but someone who is clinically obese. Uh, will be characterized as handicapped or disabled and will be entitled to the accommodations and the protections afforded under the Affordable Care Act and New Jersey's Law Against Disability. Most states have enacted something like New Jersey's Law Against Disability. Okay, I don't know how many of you have, prior to taking this class, considered injuries and preventable harms uh, as public health conditions, but they really are. We talked about communicable disease. That's the most obvious example. We talked about chronic disease, and I think most of us prior to this class would recognize that people with chronic diseases, as widespread as they are also part of the public health conversation. But when it comes to preventable injuries and harms, it's not such an obvious question. So let's take a few minutes and talk about preventable injuries and harms and um, and the sources of these. Basically, we're talking about three sources of injuries and harms, and they are occupational or environmental hazards. They're products, the products that we use, the things that we eat, the things we use for recreation, and they're risky behaviors. The drinking, the driving, the smoking, the use of drugs, legitimate and illegitimate. These are all the risky behaviors we're talking about. There are others as well, but these are the three main sources of preventable injuries and harms. They're preventable, therefore, the public health system uh, has it on its menu as something which they can work toward preventing, not eliminating, that's not practical, but certainly minimizing the incidence of these injuries and harms, and when they occur, uh, minimizing the severity of the injuries and harms. So let's look first at the occupational and environmental uh, source of injuries and harms. In 2013, almost 5,000 deaths in the U.S. were attributable to fires, falls, hazardous substances, and equipment failures or accidents related to the use of equipment. Vehicular collisions is an obvious one to us. We all have either been in an accident or know someone who has been in an accident. Hopefully, we don't know anyone who's been severely injured in an accident, but we do know that cars, trains, buses, planes are involved in accidents, and that when they do, injuries and deaths result. In 2014, 38,000 deaths were attributable to vehicle accidents. Uh, Most of the automobile accidents that which are the most common by far, of course, are chalked up to recognition error. By recognition error, we're talking about inattention due to cell phone use or GPS use. And it's been statistically borne out that recognition error of this nature statistically is almost equal to the risk of DUI in terms of causing accidents. Uh, Other sources are products, toys, food. In 2015, almost over a quarter of a million toy related injuries resulted. Over the years, we've gotten better at that. I do remember as I was growing up, I don't think there was anyone really watching to see that toys were safe. So, for instance, if you go to a toy store today, if there are any left, I don't know, but if you're buying toys for children, there are age advisories on the corner of the box with Legos. The ones with a million tiny pieces might not be suitable for anyone under the age of 10. So they're trying to restrict them to age appropriate. Also, some of the toys were made from materials in the past which were dangerous, toxic, or even flammable. Some toys that were used in the past were just dangerous. They looked dangerous, yet if used properly, they could be fun. I'm thinking of lawn darts. Lawn darts was a thing. You might not have heard of it because they've been out of business for a long time, but basically, it was a steel dart. With a little bit of a fin on the back of it, and you would throw the rings around the backyard, and then at a distance, you and your friends would lob these steel tipped darts into the air and try to get them to land within the circles and get points. Inevitably, someone picked up a lawn dart and playfully threw it at another kid or an adult, and someone was injured. So, lawn darts are no longer a thing. That's another example. Foodborne injuries. Are a big deal. Occasionally, fragments of glass or other foreign substances end up in food. As we know, toxins, botulisms, E. coli, things like that can end up in food. Food can be tainted. When this happens, injuries can result, and in some cases, they're severe and can cause death. Poison, of course. The old skull and crossbones labeling on products has been around for a long time, but it's been recognized that there are some common products around which contain toxins or things that might be classified as poisons, which we might not have readily been aware of. In 2015, there was a California class action against a winemaker because it was determined that there was a level of arsenic in their wine above trace levels, a dangerous level of arsenic. That's another example. Drugs, of course, both illegal and prescription drugs, cause injuries and harms. This is quite obvious, and the public health system is sharply focused on that. I hope to give you access to some materials on the recent litigation, um, the class action suits against the opioid manufacturers. There have been some very notorious lawsuits and some gigantic settlements against those companies because they were putting out those products in pharmaceuticals for prescription, but they were putting them out really indiscriminately and irresponsibly. And as a result, many people ended up addicted to these substances. So I'll let you know a little bit more about that. And I'll post it and I'll give you an announcement and tell you where to find it. The opioid crisis has risen to such a level that many state governments have declared states of emergency. You know that there are some states where it's more prevalent than others. I believe places like Vermont and New Hampshire, perhaps Minnesota, have very, 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 very severe opioid problems. A lot of times the gateway is a prescribed Oxycontin, Percocet, something like that. And then at a certain point, it becomes easier to buy street heroin because it's cheaper, it's more accessible. You don't need a doctor. Um, the President of the United States in 2017 declared a national state of emergency. I'm not sure, other than that, there's been much done at that level to combat the opioid crisis, but nevertheless, it's still with us. One of the things that the public health authorities have been able to do is to make naloxone more available so that we can save some lives anyway. CDC has enacted guidelines for prescribing opioids, and it's much more severely restricted than it used to be. And I mentioned the litigation against the big pharmaceutical companies, and I'll give you some more guidance on that. Violence as a public health problem. Well, sometimes, we don't think about violence as a public health problem, but I think it is. I might have alluded to this in one of our Zoom check ins, but I believe that gun violence is definitely a public health problem, but we have a constitutional impediment to dealing with it in the best, most effective way. Gun violence in schools since Columbine. Um, I think as of 2015, there'd been 33,500 total deaths, not just in school, from gunshot wounds. In 2015 alone, there deaths due to gunshot wounds were that high, but it really hits us hard when it takes place in a school. So the effort to address gun control legislation at the state and federal level is front and center in the news, and it's controversial because the countervailing constitutional liberty, of course, is the Second Amendment right to bear arms. So it remains to be seen where that will go. A lot of that has to do with who's in the White House and who controls the Senate and the House of Representatives, but also it depends on the composition of the Supreme Court, because inevitably these cases work themselves up to the Supreme Court, and the justices fairly predictably vote along ideological lines. At present, there are 5 conservatives and 4 liberals. Occasionally, one of those conservatives, Chief Justice Roberts, swings over. He's been fairly reasonable. He was instrumental in upholding the Affordable Care Act, and I'm not sure how he would go on a gun case were that to come up. But in any event, sometimes common sense is not a good predictor of how these issues are going to come out legally. Beyond gun violence, there's domestic and interpersonal violence. These are mainly handled at the state and local level under police powers, but rape, stalking, interspousal abuse, child abuse, and suicide. Believe it or not, suicide for a long time in most states was against the law. It was a felony. Who do you prosecute when someone commits suicide? Well, they would try to prosecute someone who attempted suicide in those days, but cooler heads have prevailed, and it's understood now that suicide is a manifestation of depression or some other problem. Sometimes it's a manifestation of a chronic illness which hasn't been addressed. In any event, most of those criminal laws have been stripped away. But the state and federal government, the state governments and the local governments are actively involved in the domestic and interpersonal violence um, campaigns. One way that government attempts to control preventable injuries and harms is through the use of tort law. Now, I don't know how many of you are familiar with the term tort law or tort, so a quick introduction is in order. As you know, generally speaking, the courts and the law are divided into two major categories. One is called criminal law, and one is called civil law. When we talk about civil law, um, we're talking about dealing with the things that people do to one another or that companies do to individuals or other companies, which are wrong. They are called civil wrongs. I want you to imagine a car accident where you're stopped at a red light and someone comes up behind you and hits you in the back at that red light. They have committed a tort, the tort of negligence. Okay. Also, a tort can be an intentional tort, not just a mistake. A fight in a bar resulting in a serious injury from by incurred by one person as a result of that fight could also be a tort. That's an intentional tort of assault and battery. So a tort is a civil wrong, either intentional or unintentional, resulting in a harm to a person or group. By person, we don't always mean a human being. Either a person in the law can be a corporation or a partnership. A corporation is considered to be an artificial person. So a civil wrong resulting in a harm to a person or a group, which is compensable, meaning that there are damages. There's been some economic loss of some kind or some physical loss, which can be translated into dollars. So when someone says, I'm going to sue you for that car accident when you hit me at the stop sign and damage to my priceless 1957 Ferrari sports car, that is a description of a tort lawsuit where someone will be seeking damages because of the negligence or the inattention or the unintentional civil wrong committed by the person who caused the accident. Tort law can be effective in preventing injuries and harms because it punishes the wrongdoer, the person who has made the mistake. And when wrongdoers are punished, the hope goes, the theory goes that they will be discouraged from repeating that behavior in the future, and that it therefore encourages reform and good behavior, and actually causes people to rethink how they go about doing their business. There are basically three theories of tort liability, and the first is intentional tort. That's assault and battery. That's the bar fight I described to you, or maybe you're at the soccer game and your little brother is fouled and it's not called, and you get into an altercation with the official on the field, and you run out and hit him a good shot. That would be the tort of assault and battery. Negligence is the car accident, but it's not always a car accident. It could be anything. It could be the failure of you to uh, take care of your property, the result of which is someone walking past your property or using your property and getting hurt. The third category is what we call strict liability, and this is where the act is not intentional, nor is it necessarily negligent, but because either the product that you're using or the activity in which you're engaging is so dangerous that regardless of your fault, the law is going to impose some liability on you. So each of these is used in the public health effort, and we'll see in a few minutes how that works out in specific cases. Okay, so as we've mentioned, there are three theories of tort. Those are intentional torts, negligent torts, and strict liability. Let's start with negligence. Negligence requires that we first establish a standard of care, a duty, if you want to call it that. Next, we have to prove that that duty or standard of care has been breached. Third, we prove that the breach has proximately or directly caused an injury. And finally, we must prove that that injury has resulted in actual damages. There are personal injury damages, there are economic damages, perhaps the loss of the ability to work. Um, all these things are considered damages. The difference in a civil case involving a tort it really comes down to the burden of proof. In a criminal case, as you know, the state, the government, must prove the crime beyond a reasonable doubt. This is a very high standard. Yet in a civil case involving a tort, the standard is only a preponderance of the evidence, which means that it's only slightly more likely than not that the person was responsible. If you wanted to reduce it to numbers, which is a way of thinking about it, 51% chance he did it, 49% chance he didn't do it, something like that. Okay, so you get the idea. Yeah, it's a much lesser standard of proof. So, negligence, standard of care, a breach of the standard, causing an injury, and causing actual damages. Examples are medical malpractice in the medical field, where we would have to prove that a doctor uh, violated a certain professional standard of care, resulting in an injury, resulting in damages. Automobile accidents. Yes, of course, it's easy because we have traffic laws. So the violation of a traffic law resulting in an accident which caused an injury and damages would be a good example of a proof of negligence. Slips and falls. Let's assume we have a law in our town that says that after a heavy snow, we have to clear our sidewalk or maintain our property in a safe condition. Or we have a tree which is on the verge of falling down across the sidewalk in the street and we never do anything about it. We have a duty then to address those property condition issues. Failure to do so may result in a negligence case against us and liability. An intentional tort is not a mistake, but it's an intentional act of an individual or a company against an individual or another company, resulting in a harm. So this is if you wanted to imagine a situation where someone assaults someone in a restaurant or a bar, causing an injury, and that person had no legal excuse or defense to it, that would be an intentional tort, which could result in the liability of the person who engaged in the assault. Examples in the media would be the O.J. Simpson case. If you remember, he was tried for murder and acquitted, and the standard of proof there was beyond a reasonable doubt. The estate of the victim then brought a civil suit for the intentional tort of assault and battery, resulting in the death of the victim. And the standard of proof then was only a preponderance of the evidence. So, although he was acquitted in the criminal case, there was a verdict against him entered in the civil case for the intentional tort. Other intentional torts are false imprisonment, defamation. Defamation is slander, libel, telling a known lie about someone to the effect of damaging their reputation in a serious way. That's an intentional tort. That doesn't often come up in the public health context. Strict liability is probably the most important one now when we're talking about the avoidance of injuries and harms. Strict liability is liability which is imposed even where there is no standard of conduct violated. There is no duty violated. And it comes about primarily when we're talking about activities which are unavoidably unsafe or substances which are unavoidably unsafe. In other words, these activities or substances have some utility in our society or in our commerce, but there's no way to make them safe. When injuries occur because of these activities or substances, then the persons who are responsible are held to a strict liability standard, and they will be required to pay compensatory damages for personal or economic injuries, and also punitive damages, which is a further amount of damage, oftentimes many times more than the compensatory damage, for the purpose of punishing them and encouraging them to change their behavior, make their products safer, make their activities safer, changing the way they do their business. So, this strict liability, when imposed on unavoidably unsafe activities and substances, should be thought of as just the cost of doing business, because obviously these substances and these activities, if they have utility in our society, are going to continue, but it is understood that people are going to get hurt as a result from time to time. We hope to minimize the incidence of these injuries, these accidents, but when they do happen, liability will be imposed, and it's often quite severe. Again, it's the cost of doing business. Strict products liability is the one we most often deal with, and it has to do with products that we use in our daily lives, mainly consumer products. And strict liability related to products can result when a product is defectively designed, manufactured, or when the warranties or labeling or representation that accompanies the product is defective in some way or misleading. Without a strict products liability theory, these sorts of defects would be very difficult for the common man who is injured by these products to prove. How, for instance, would you prove that your snowblower is defective? What do we know about snowblowers? We would have to get a snowblower expert to come in and talk about the snowblower and how to design one, or why it was manufactured defectively. Uh, Basically, the standard of proof would be so high that it might discourage injured people from seeking redress in the courts. Products liability was designed to make that a little bit easy and a little bit more cost effective. So, some of the things that we deal with in our lives, like cars and toys and ladders and power tools, are all subject to product liability theory. And of course, the main goal of product liability theory and the verdicts that result is that the verdicts will be so heavy when something goes wrong that they will encourage companies to change the way they do business and make their products safer. Not all products are held to this standard, however. Tobacco, guns, alcohol are not held to the standard, so that something like a gun is an unsafe object. There's no question about it. The misuse of the gun can result in serious injury and death. And every time a gun is used in a mass shooting, the conversation about holding the gun manufacturers responsible comes up. However, the government has given the gun manufacturers blanket immunity to liability when the guns are used in this way. Um, the main concept to bear in mind here is to always consider the question of whether or not a product is safe when it's used in the way it was intended or in the way that a reasonable person might predict it would be used. Um, Think about buying toys for children and the advisories on those toys about the suitability of the toy for certain age groups. You certainly wouldn't give a Lego set with 10,000 tiny pieces to a toddler because the pieces could be ingested. So some of it just makes good sense. The main question here is always going to be, does the utility of the product outweigh the harm? If the utility of the product does not outweigh the harm, then it could be that the government will ban the product entirely. Other examples are exploding e-cigarettes, overheating in someone's pocket, causing a horrible burn injury. In the past, there was a car called a Ford Pinto. It had a gas tank which was poorly designed to the extent that when involved in a car accident impacting the gas tank would explode, incinerating anyone in proximity. These were held to be design defects, and the Ford company suffered uh, extremely high damages as a result and took the Pinto out of circulation or redesigned the tank. A failure to warn about a product can also result in liability. If you go home and have a ladder around the house, and if you haven't peeled the labels off, or next time you go to Home Depot, take a look in the ladder department. If you see anything less than 5 labels on the ladder, give me a call, because essentially they'll tell you where to set it up, make sure the ground is even. Don't stand on the top step. Don't stand on the little platform used to support the paint can. All sorts of things like that. And each one of those labels, I would bet, stems from a lawsuit in the past where someone did exactly that behavior and got hurt as a result and sued the company. So the hope is that the verdicts will lead to redesign and reform. Finally, very quickly, I just want to touch on the use of criminal law in the public health field to try to change conditions. Um, Criminal law sometimes works in tandem with civil law in this field. If you think about the DUI laws, which are criminal laws, they're designed to modify behavior and discourage drinking and driving. By the same token, accidents resulting from DUIs could result in civil suits and huge damages. Um, Intentional violence is, of course, always subject to criminal law. Intentional HIV transmission has been criminalized, of course. And corporate neglect can result in criminal liability. So often we talk about putting a product in the stream of commerce. The product hurts someone, the person sues the company under a strict products liability theory, and the result is damages. And the result is compensatory and punitive damages. And that might be discouragement enough. But when the corporate misbehavior or neglect or inattention reaches such a high level, then it's possible that the company will be subject to criminal liability as well. The example used in the book is the Peanut Corporation of America, where its CEO, Stuart Parnell, was sentenced to 28 years in prison for basically allowing the company to manufacture, sell, and distribute bad peanuts. He knew they were contaminated. The company knew it. They continued to put them out. They took the risk. People were sickened by them. OSHA initiated the prosecution, and or the Food and Drug Administration, probably in that case, initiated the prosecution. And you had criminal liability to go along with, I'm sure, plenty of civil liability. OSHA will initiate prosecutions for severe violations of the occupational safety regulations under their jurisdiction, and they have acted forcefully in under the Mine Safety and Health Act in the past. So you can see how criminal liability can be paired up with civil liability to try to modify these behaviors for the purpose of limiting and reducing the incidence of preventable injuries and harm, and limiting the severity of the injuries when they do occur.